Gutman Scrande with Dwayne Morris on behalf of appellant Elaine Kaplan. I'd like to request 4 minutes to reserve for rebuttal.
When you see the yellow light come on, you will be into your rebuttal time.
Thank you, Your Honor. This court should reverse Judge Gold's final judgment confirming arbitration award pursuant to section 44.10410A because the arbitrator did not comply with the applicable rules of procedure set forth for the parties' arbitration. So how did we get to the applicable rules of procedure for the parties' arbitration? Well, the parties entered an agreed order to remove their case from the trial docket. The underlying dispute was a cross-surcharge trustee action. They removed the case from trial in favor of an alternative dispute resolution mechanism known as MEDAR, where first they would mediate their dispute with an individual, and then if they reached an impasse with the same neutral, they would enter voluntary binding arbitration. Now, that voluntary binding arbitration was to be governed by the parties' joint statement of claims and issues. This collaborative 24-page document set forth 8 different trust expenditures that the parties agreed to arbitrate. That was the procedure that the parties set forth for their binding arbitration.
Wasn't the intent originally, though, to dispose of all issues that were disputed?
That's correct, Your Honor. All the issues that were disputed in the underlying trust litigation were embodied in that joint statement. Those were the 8 trust expenditures that the parties had agreed they were going to trial on. In fact, the joint statement itself was part of an agreed pretrial memorandum, and that's what the parties had narrowed their issues similar to a trial of what they would be covering. So it would dispose of the action, the voluntary binding arbitration. So then the arbitrator proceeded, they went to mediation, they reached an impasse.
If it was to dispose of the action, what was to be left after the arbitration?
There was to be no further dispute. The parties never argued that they were to each receive the remaining properties in the trust 50-50. So the properties that were not allocated according to the arbitrator's award were to be distributed exactly how the trust and the decedent intended, 50-50. It would be a ministerial task, just signing over the property rights like a PR's deed. So then in the award, the arbitrator capably adjudicated those 8 issues that the parties had agreed to. But in addition, and in contravention of the parties' agreed upon procedure, he also decided in a miscellaneous provision at the end of his award to distribute 2 pieces of real property interest belonging to the trust known as Arco and Twin Brooks. That's completely violated the parties' procedure. And Arco and Twin Brooks are not referenced in the underlying pleadings whatsoever. The rent issue regarding Arco is not referenced in the underlying pleadings, and it was not referenced in the joint statement. This issue was simply not in dispute among the parties.
You appealed this to the circuit court, though, right?
That's correct, Your Honor.
Okay, so you got a ruling from the circuit court.
We got a final judgment from the circuit court confirming the award, correct, Your
Okay,
Honor?
so then why are we here?
We're here because this is a final judgment entered by the circuit court, and we have the right to appeal pursuant to 9.030B1A as a circuit court final judgment.
What about Chapter 44?
Chapter 44, I believe Your Honor is referring to the limitation perhaps referenced by appellee in their answer brief, and that limitation has no application to the current case.
Why?
Section 44.104 is a pretty interesting statute. It talks about trial resolution judges and voluntary binding arbitration, kind of skips back and forth. Sometimes it talks about one, sometimes it talks about both, sometimes it doesn't reference either. Subsection 404.10412, the one referenced in the answer brief, it explicitly talks about harmless error, which implies a trial setting, talking about trial resolution.
That provision was there before this statute even discussed the voluntary trial resolution.
Well, so basically, the way Section 44.104 works, Your Honor, is we have subsection 10A talks about appeals of voluntary binding arbitration. Then subsection 11 talks about only trial resolution judges. And then subsection 12 includes the limitation.
But the limitation was there before the trial resolution subsection was added, when it was just called voluntary binding arbitration, when the statute was first enacted. It did not relate to trial resolution, but it included that limitation.
Well, Your Honor, I believe when the statute was amended to include both voluntary binding arbitration and trial resolution, the legislative history cited in our reply brief explicitly states that that portion of the limitation is only to apply to trial resolution judges. That's the staff analysis for the House bill.
But would that make sense since it was in the statute before it, trial resolution judges were referenced?
I believe that they wanted to just make voluntary binding arbitration more accessible to the parties, and
So they were removing that from voluntary binding arbitration?
they were removing the limitation from voluntary binding arbitration, yes, Your Honor, to apply to trial resolution judges. And in fact, there is district court precedent for reviewing a circuit court final judgment confirming an award. That's the Teuberman case cited in our reply brief. And it's a very similar factual circumstance where the arbitrator went beyond the permissible authority that he was allowed to review, and the district court there actually reversed the circuit court final judgment in the same exact posture here. That was a mediation arbitration hybrid dispute, and the award went beyond what the arbitrator was allowed to do.
That was the 682 case, wasn't it?
No, Your Honor, that was a section 44.104 case. It was a hybrid mediation arbitration voluntary binding framework. Same thing we have here. It's exactly procedurally on point. And not to mention the fact...
So Teuberman was a Chapter 44 case?
Yes, Your Honor. Teuberman v. Teixeira. And not to mention, on top of that, appellant Elaine Kaplan also has rights to, and I see that I'm entering my rebuttal time. I'll save that for my rebuttal. Thank you.
Welcome back.
Thank you, Your Honor. May it please the court. I'm Robert Hauser for Abby Epstein, the appellee. Also with me are trial counsel Mr. Singer and Ms. Gallagher from the Commodore Singer firm. This order should be affirmed, or the appeal dismissed, one or the other, for three reasons. First reason, Chapter 44.104 doesn't allow them to take a second layer of appeal, having appealed to the circuit court. Number two, they haven't preserved the error. There is almost no record of this hybrid mediation arbitration. There's no trial memos, there's no evidence, there's no evidentiary objections, there's no transcript, there's almost nothing from the underlying order, and that puts us at a disadvantage because they haven't met their burden of showing that they did anything below other than write a letter many, many months after this proceeding began to protest the inclusion of some evidence or issue. And third, they're substantively wrong about what the arbitrator did. All claims as to ARCO were denied. So even if the arbitrator considered them, and even if they're right that he shouldn't have, which we disagree with, he denied them. So the only thing that the arbitrator does in that last paragraph of his award is give one asset to my client and another asset to their client. And we can speculate why he did that. It was probably to separate the feuding parties so that they wouldn't have joint ownership going forward, and it would prevent future litigation. So it was a wise thing to do.
Were those two items included in the document that he discussed that set out the things to be decided?
Not as issues, but they're assets in the trust, and the entire trust needed to be paid out. No one's going to argue otherwise, that the entire trust needed to be paid out. And so this arbitrator had the power, everybody agrees, he had the power to distribute out the entire trust. In fact, in the transcript of our argument in front of Judge Gold below, their counsel, Mr. Goldman, conceded that if the arbitrator had distributed ARCO and Twin Brooks 50-50, that they would have no objection. So it's not that the arbitrator didn't have the power to distribute ARCO and Twin Brooks. They concede that he did. What they're complaining about is his substantive decision to do it in such a way that the party's ownership is now separated. And that's an arbitrator doing something under substantive law. It's not a procedural error. It's just something they don't agree with. And that's not something that can be reviewed under 44.104. It's not even something that could have been reviewed under Chapter 682. So first of all, it's not an error, because the entire trust did need to be paid out in one way or the other. And remember, this was a claim where the arbitrator was supposed to be looking at who did what and who was entitled to corrections on account of various breaches of fiduciary duty, and settle the ledger, on each side, some to Kaplan, some to Epstein. And there's also no dispute that the arbitrator was entitled not only to award cash to both sides, but to award stock, because one of the other assets that was here that was being distributed was stock. It was even possible that the arbitrator would run out of stock, in which case he'd have to dip into some other asset by necessity. So all he's done here is basically distribute out the trust and complete the litigation as the parties agreed. So back to Chapter 44. It is completely clear, I've now read this statute a bunch of times, it's completely clear that the legislature was trying to make it so you only get one appellate bite at the apple. When parties go to a voluntary trial judge, that results in a judgment, and the appeal is to this honorable court. When parties go to arbitration, they get an appeal, which is something that probably strikes us as odd, because under under 682 cases, a party that's unhappy with an arbitration award files a Chapter 682 proceeding. They get a judgment from a circuit court, and again, the appeal is to this court. But 44-104 contemplates that you actually appeal to the circuit court, and we had an appellate proceeding in front of the circuit court, which I had never seen before in 20 years of doing this. They filed an initial brief, answer brief, reply brief, and we had oral argument in front of a circuit judge over the merit of an arbitration award. And in that circumstance, and by the way, it's 44-104-10 calls it an appeal, which again is unusual, but that's what they call it. And then 2 subsections later, it says harmless error applies in appeals, and there's no further review unless a constitutional issue is raised. So to me, that is completely clear that this court is deprived of the ability to review anything other than a constitutional issue, which is not raised. Now, their construction of the same statute would mean that the further review limitation applies from the DCA level to the Supreme Court. And I submit that that is an absurd construction, because everybody knows the Supreme Court can't hear an appeal of almost anything. The only things that come to mind are death cases, and when a lower court holds that a state statute or a federal statute is invalid. So that would be an extraordinarily odd way for the legislature to restrict something that is already deeply, gravely, severely restricted. So the only reasonable construction of 44-104 is a litigant gets one bite at the apple, one appellate bite at the apple. The appellate bite was taken down in Broward Circuit Court, and we got a result, and so I think the appropriate result is for this court to dismiss.
What is your position on the Toberman versus Tessera case?
I don't think that the jurisdictional issue is covered there.
Well,
If it is, I could be wrong.
wasn't the issue in that case that it involved a child custody dispute, which is specifically excluded from the statute?
That would make perfect sense. But I don't think there's any case, including Toberman, that addresses this jurisdictional issue, and I'm frankly not surprised that nobody spotted it, because it's not the best statute I ever saw. It's lousy, okay? But in any event, I didn't move to dismiss this appeal because that would have just held up resolution more than has already been, and this case needs to be over one way or the other. So this panel can dismiss this appeal on the basis of 44-104 sub 12, and that's the end of the case. On the question of preservation, the law is very clear that a litigant that wants to come in and show that a judge did something wrong needs to show that they made a contemporaneous objection and they got a ruling on the objection and that they lost. And there's just no way to show any of that here, and it's unfair to us. The parties' trial memoranda, we don't have them. We don't know what the other side submitted. My trial counsel all feel that everything that was done in the arbitration award is the product of the dialogue that was had without objection below, but there's no transcript to show that. There's no trial memoranda. There's no evidence. There's no objections. There's no orders overruling objections. We have nothing to review whatsoever. And so under every principle of appellate review that I've been taught, I don't see how this court can find anything other than that if judge wasn't a judge, it's an arbitrator form, and if he thought the issue was before him, it was before him. And then my final point is, again, he denied the claim. denied it. So he didn't grant any relief on the basis of a claim that they say was improperly submitted. What he did was he separated the interests of the parties that are in the trust so that they won't be bickering in all eternity, although we're getting close to all eternity.
If we were to agree with you, does it matter which point we agree with you on?
Well, it might change whether you dismiss or affirm.
That's my question.
If you dismiss, then you never get to any other question. If you affirm, then it could be, it depends on what the court writes. The court could just affirm and we never know why it affirms, or the court could say affirmed on the basis of 44-104-12.
That's why I asked you the question. If we were to agree with you on any point, does it matter which one we agree with you on,
Well,
to you?
practically no. But technically, I think a 44-104-12 ruling is a dismissal. And then it's worth mentioning that I've moved for attorney's fees under Chapter 682. And my position is that Chapter 682 applies to everything that has to do with arbitration unless 44-104 says otherwise. And I don't want anybody to confuse that. As far as I'm concerned, Chapter 44 governs. It is the controlling law here, and Chapter 682 would only apply if 44-104 were silent. So, if there's no questions, I'll conclude.
Thank you. Let me just ask you, because I'm looking at the case that you referred to earlier in Toberman, and it doesn't look like the court addressed the jurisdictional issue at all, but as Judge Quinn pointed out, really dealt with the issue of that there's an exception for child support or child custody matters.
Absolutely, Your Honor, and that was the substantive issue at dispute, but at the end of the day, the district court was reviewing the exact same order that we're asking the court to review here today, which is a circuit court final judgment confirming an arbitration award pursuant to Section 44.104.
I'll give you that.
It's a final judgment. And Your Honor, I want to conclude the point that I was making before, and it addresses Eppley's argument. There's also an additional right to appeal here for jurisdiction, and that is Rule 9.170B15, which is, this is because this is a circuit court order effectuating a probate distribution, and it would be unfair to strip appellant Elaine Kaplan of her right to appellate review under that rule, given that her entire gripe with this matter is that she did not consent to a distribution of these assets, and therefore she should not have consented to waiving her appellate rights here. And that's exactly what we have here. We have an impermissible rogue arbitration. Now,
Well, if we have a conflict between the statute and this rule, which one prevails?
Your Honor, I don't think there is a conflict because Section 44.1...
Let's assume there is.
Let's assume there is. I think that the rule would prevail because that rule specifically grants jurisdiction for a completely different issue, which is effectuating a distribution of probate assets. And that part was never agreed to by the parties to be at issue. Arco and Twinbrooks were never agreed to be distributed. Arco and Twinbrooks were never agreed to be adjudicated. There was no dispute over those properties whatsoever. The parties explicitly agreed to a procedure where the arbitrator was only to determine whether trust expenditure was in the nature of a surcharge, the amount of that surcharge, and to allocate funds to remedy that surcharge. That part's important. That's at the record 1906. That's the only type of remedy that they agreed to. No distribution of assets, no upsetting of the decedent's 50-50 intent. And that's very important. That's the procedure that was violated.
But looking again back at the case of Toberman, it talks about the fact that the statute was specifically designed to resolve the entire dispute by using the term dispute, which means all litigation. I mean, they do discuss that quite...
That's absolutely correct, Your Honor. In this case, the dispute between the parties did not include Arco and Twinbrooks. What Appellee is discussing is a future speculative dispute about a landlord-tenant argument, which is exactly how they phrase it in their answer brief, a landlord-tenant dispute in New Jersey after these parties own the properties as individuals, not as co-trustees. Their capacities in this litigation was only as co-trustee. They can't even bring a lawsuit, I believe, under the joinder rules together as co-trustee and individually. So it's not even legally possible for that dispute to have been at issue in the underlying litigation. And again, these two properties were not mentioned in the pleadings that had framed, they were about to go to trial. They were not mentioned in the pleadings that framed the issues, and there was no request for relief regarding these items. These parties did not dispute that everything was supposed to be distributed 50-50 once this trustee surcharge action was resolved. The arbitrator did that capably. Schedule A to the award, record 1860, shows he completely understood what the parties wanted him to do, allocate funds to each side of the ledger. But then he went beyond that procedure for some reason in a miscellaneous provision, and not for some reason, to avoid a future dispute. He saw something on the horizon, and he wanted to address that. And that's what the Solar case, also cited in our initial brief, says. An arbitrator can't see a dispute on the horizon and try to address that. That's not right. That's not at issue. That's not part of the underlying dispute. And what's also very important here is that the error is apparent on the face of this award because the arbitrator said, I am constrained by the parties' joint statement. If he hadn't said that, maybe Appellee's argument about preservation of error, no transcript, would hold water, but it doesn't because he reiterated his authority was just bound by the parties' procedure that they had laid out. So in conclusion, I would just request that the court only sever the portion of the award, vacate the portion of the award that's miscellaneous, and reverse the final judgment as to that point. If the
Thank
court
you
has
very
any
much.
more. Thank you.
Thank you. We appreciate your time this morning. That will bring us to the second